Thank you very much, my colleague, Mr. Mohamed. Madam Chief Justice, Madam Deputy Chief Justice, honorable members of the court, may it please you, I am called upon to look at issues number 8 and 9 on the materiality question and on reliefs. My Lord, in view of the time, I will not go into...
Sorry, Counsel, for our recording system, if you can just introduce yourself. We know you, but for our...
I apologize, my Lord. My name is Abdikadir H. Mohamed. I appear with my learned colleagues for the IEBC and the chair. My lords, my ladies, in view of the timing, I will not go into a lot of the law as far as the standard of proof is concerned. This matter is tried as far as the law is concerned. The standard is higher than 4 civil cases, normal civil cases, but does not go as far as required for criminal cases. In other words, it does not go as far as beyond reasonable doubt, but it is higher than a balance of probabilities, except where criminal conduct is alleged or there is an election offense alleged, in which case then you go to the higher proof beyond reasonable doubt. The submissions of the first and second respondent in the lead, the submission of the respondents in the lead petition at paragraph 8, page 4, deal with the law, the cases, Raila Odinga 2013, para 203, number 1, presidential election number 1 of 2017, para 151 to 152, and the courts clearly state that the allegations should not be general, they should not be bare allegations, and the standards must be met. In John Harun Mwau, at page 349 to 350, 2017, that was the holding of the courts. So the law is very clear on this matter, my lords and my ladies. I'll then go on itemizing some of the allegations or some of the issues raised in terms of illegalities and irregularities, and specifically state whether those standards have been met, and in broad case, they haven't. So there have been allegations of a dysfunctional commission. This, my lords, is not a court dealing with a corporate governance case. It is an election petition court dealing with the presidential elections in 2022. My lords and my ladies, the case of Maina Kiai dealt with the issues of the commission and the chair and their place in the process that we are talking about, in the verification process. And it's very important to understand that the petitioners want to turn that case on its head, because if you recall, what the petitioners in the Maina Kiai case were fighting against, it was the interference by the commission or the chairman in the results when they come to the National Tallying Center. This is exactly what the petitioners are asking to do. They are asking the commission to interfere with the results at that point. That is not the law. Number 2, there was the allegation that the commission is equal to the commissioners. That was dealt with by my learned colleague, Senior Counsel Kamau Karori. But let me just add that it will be absurd to say that the only elections, the only verification that is acceptable under the law is verification by the commissioners. What then would we make of the elections at the counties and the tallying and verification at the counties and the tallying and verification at the constituencies where no commissioner is present? What would we make of section 39(1)(c), which says the commission will transmit? Which commissioner transmitted when? It is the commission officers, the commission employees, and the commission is certainly more than the commissioners. My lords, that allegation, therefore, that there was a dysfunctional commission and this led to the results not being verified is not borne. The standards have not met, and it is not the law. The commission practically will need to rely on its officers across the country in the 46,000 plus polling stations for the work of the commission, including presiding officers verifying and transmitting. The next allegation broadly was the issue of the rule. Issues can be affixed to this good gentleman that the chairman was being accused of. That would be $22 and send 14 million plus Kenyan voters back to the vote and spend. The chairman is accused of single-handedly conducting himself, and it's alleged that the office of returning officer for the presidential election does not exist. I adopt the presentation from my learned colleague, Mr. Kamau Karori. But suffice it to say that we all accept that 138.10 gives a role to the chairman to declare. That regulation 87.3 gives legal roles to the chairman, and case law has given legal roles to the chairman. Those roles, when you put them together, essentially spell out the role of a returning officer. And in the old company law, the definition of a director used to go that a director is a director by whatever name called. And the returning officer is the returning officer by whatever name called, because he is undertaking the functions of the returning officer. Let me now turn to the allegations from the other commissioners and the averments in the affidavits. If you look at the totality, what you get is that these good ladies and gentlemen were either negligent or unaware of their functions, or in fact were not stating the truth as such, because the law requires for the commission to hold a minimum of 1 meeting per month. More were held during the elections. They attended all those meetings under the affidavits. The vice chair and Mr. Wanderi attended the trip you are told about in Greece, where they went to check on the presidential ballots. The announcements were made by these good people almost 70% of the time. In other words, almost 70% of the announcements done at bomas were done by these particular commissioners. And the tables were there for everybody to see where verification was happening. And they had no one stopping them from going to attend or direct if they wanted to direct. We would have shown at this point their access to the floor in the 4-minute clip, but in view of time, I will skip that. But I would urge the court to look at that video clip to show the extent of the operations of the commissioners, and especially these 4, in terms of the operations at bomas. Then we go to the 27 constituencies. The affidavits clearly show that those constituencies were tallied and they were in fact verified, and that the record will clearly show that what was remaining was the announcement. And the 4-second clip will show you the environment and the fracas at the announcement podium at the point in time when Professor Gulie was to go to that podium to announce the 27 stations which had been verified and tallied. I'll play the 4-second clip. Thank you, Sonia. Please. Yes, this is bomas just before Professor Gulie was to announce. This is covered in the affidavit of the chairman, and is also touched on in the affidavit of Professor Gulie and also the chief executive, Mr. Marjan. My lords, that was the environment at that particular time. It was practically not possible for Mr. Gulie to announce. Our contention is that lack of announcement does not go to the level where you would consider those constituencies untallied or unverified. What then were the aim of the commissioners when they say we wanted to, quote unquote, own the results? Because verification is a very simple process. It has been defined. I'm not going to waste a lot of time on it. Tallying is a mathematical process. The only other verification required, other than compare the forms, was has the candidate met the 50% plus one. What the commissioners actually wanted to do was what was stated in the affidavits of the chairman, the Professor Goulier, and Mr. Molu, which was to moderate the results so that a pre-agreed or pre-arranged result can be declared. That is what they wanted. What they wanted was for a meeting to sit over the decision of who will be president, not the voters, not Form 34A, not the polling station as the law is, but for a meeting of the commissioners at the National Tallying Center after the work had been done to moderate. That is illegal, it is unconstitutional, it is completely unacceptable. And this is in the affidavits. There were two meetings prior to that final meeting. One where there were visitors from the security agencies and the other from individual Kenyans. And those meetings were confirmed by all the protagonists. And this really was the scheme. This was the rupture. You asked yesterday, how come we had not heard of this dysfunctional commission earlier? Because it was a process that was going on, and at the point of disagreement is at the point where now we have rupture. And from that point onwards, those commissioners are part of the scheme, and this time instead of announcing the wrong results, it is aimed at getting this court to overturn the results. That is the scheme. That is the decision the commissioners wanted to be part of. In terms of technology, there are a number of allegations. I adopt the presentation from my colleague, Mr. Gumbo. In terms of the numbers, I adopt the long presentation of Mr. Mahad. And I would stop there in terms of the allegations. Suffice it to say that there have been many, they have been sensational, they have remained unproven, and they are not worthy of the level required to overturn the presidential elections of this country. Let me now go to the remedies very briefly. And the remedies, just one point in terms of the earlier issue. There was a push for moderation. That essentially is to overturn the elections. There was interference from state agents, again asking for a specific. Those are averred in several affidavits. There was the issue of the DCI and certain other state agencies. Contrary to the law requires that under Section 105 of the Elections Act, that all state organs and state officers must give assistance to this commission during this difficult period. Contrary to that, the DCI was indeed an impediment to the holding of the elections and to the functions of the IEBC at that point in time. There were very many officers of the commission picked from the tallying center, outside the tallying center. It is not a coincidence that the four commissioners refer to those staff members which were then picked by the ATPU. Ask yourself, what is the anti-terrorism police unit got to do with our elections in bomas? Why would the anti-terrorism police unit be involved in the tabulation verification exercise at bomas? And that scheme, that assault on our democracy is what you are being asked now at the tail end to. Let me also refer you to the affidavits of the commissioners where they say that the election process was okay until the very tail end. That tail end is where the matters went haywire. Let me go to the reliefs, my lords and my ladies. The reliefs as known by law in terms of the Constitution is at 143. The Supreme Court if the Supreme Court determines that the election of the president-elect is to be invalid, a fresh election shall be held within 60 days after the determination. And Rule 22 of this court's presidential election petition rules empowers the court, after hearing a presidential election petition, to either dismiss the petition, which is what we are urging the court to do, what our clients are urging the court to do, or to declare the election of the president-elect either valid or invalid, and invalidate the declaration made by the commission under Article 139(5), and then orders to payments. There was a reference to Section 80 of the Elections Act, and it states that the court has additional power to, quote, direct the commission to issue a certificate of election of a president if, upon recount of the ballots cast, the winner is apparent and that the winner is not found to have committed an election offense. Our view is that this is not operative in this case. Number one, this section assumes a recount. We have no recount in this case. Number two, it's not specific to the presidential elections, as is the case with the Constitution. And number three, it says that as a precondition, as a condition precedent, whoever is getting the benefit of that relief must, of necessity, have not committed an election offense, which presupposes that there is a process for that to have been determined, which has not happened in this case. In any event, it is the contention of the petitioners that indeed the petitioners or their agents are guilty of presidential or of election offenses, and therefore they ought not to be entitled to that relief. But can I go back to the relief sought by the petitioners, especially in 005? They are very convoluted. There are many. They are conflicting. If you look at, and some of them are strange. For example, there is in paragraph 18 of the remedies sought in the petition number 005, you are asked to uphold the decision of the four commissioners in rejecting the declaration. No such decision or no such lawful decision exists. You are asked in paragraph 9 to order directing IEBC to tally and verify, then declare. That has already happened. The tallying and verification has already happened. You are also asked to find that the elections were held in complete contravention of the Constitution, yet declare under section, hopefully 84, the petitioners, the president-elect and the deputy president-elect. Those two do not head to the same. And then you are also asked to get the election invalid, in which case the section kicks in that there will be a rerun in 60 days, yet to hold that the IEBC, as currently constituted, cannot hold the election. In which case, again, you have a conflict that is not subject to be determined. So our view is that the totality of the relief sought raise a lot of problems, as mentioned by the judges on a number of occasions. In terms of the reliefs we are seeking the reliefs as listed out in the responses, all of them, and jointly. We are also seeking reliefs as far as the chairman is concerned, as far as the number of criminal actions stated or alleged in the respondents. I adopt all the affidavits, my lords and my ladies, stated by my learned senior Professor Gideon Mugai, and the presentations thereafter. Suffice it to say that what we have witnessed is at the tail end of a very long process. We in this country have gone through a lot of reforms as a result of elections. If you recall, the entire ECK was disbanded by legal fiat as a result of an election. Thereafter, we have had to completely redo our election infrastructure. We have come to the point where this court 5 years ago laid the law. Now, if you look at all those steps, we have taken radical steps that have cost treasure, that have cost lives, that has cost livelihoods, including staff members of the ECK who have either died in office or who have been fired as a result of being told you have all been disbanded. Our law has no problem, my lords. Our elections have no problem. The problem lies with our politics, and the problem lies with our political culture. That cannot be legislated. It cannot be delivered through litigation. It has to be elsewhere. Men and women who run for office in this country must accept that it is possible to win. Indeed, it is even more likely to lose, because typically an election involves more than two people, and the chances of the losers being more than the winner are very high. Until we accept that, we are going to be harming the country, we are going to be harming our institutions, we are going to be hurting independent institutions and individuals who work in those institutions. Kenyans who give a lot, ask for nothing, and get to be denigrated in the hallowed halls of this court. My lords, I will stop there. I will ask my... Thank you, my lords and my ladies.
My lady, learned members of the court, it gives me great pleasure to return back to the court